Waikato River.
Mr. Chair.
David Bennett.
I move that the question be now put.
Chris Hipkins.
Very much, Mr. Chair. Well, there you have it. They don't like it. They don't like it and they want to shut it down. They want to end the debate because it's not going well for them. It's not going well for them because they know that New Zealanders do not support this piece of legislation. New Zealanders know that we inherited these assets. We inherited these assets from those who came before us, and this government has no respect for that whatsoever. They're ready to hock them off. Hock them off, forget about future generations, forget about leaving anything for them, just sell it. Just sell it, because if they can't cut it, they want to sell it. That's what this government is all about, and they don't want to talk about it anymore, and so now they're trying to shut the debate down. Now, it's no wonder they don't want to talk about it, because this bill is riddled with holes. And I want to talk in particular about Clause 15, 3C. Clause 15, 3C. This is an incredibly important clause because this is a clause that under normal circumstances would never get through this House. It would never get through this House because this is what's known as a Henry VIII clause. It's a Henry VIII clause in the sense that it gives the government, without reference to Parliament, the ability to change the law. It gives the government, by order in council, the ability to change the law without reference to Parliament. We call it a Henry VIII clause because in the proclamation by the Crown Act of 1593, Henry VIII effectively gave himself the power to do just that, to basically make laws by a proclamation without any reference to Parliament. These days, that's frowned upon. These days, we think it's a good idea that where the law is going to be changed, that the Parliament should debate and vote on that. This clause here gives the government the ability to change this bill once it's passed without coming back to the Parliament to have that approved. It is a constitutional outrage. It is wrong. It is absolutely wrong. And in fact, this Parliament has recommended against such clauses. The Regulations Review Committee in this Parliament was set up, at least in part, to prevent those types of mechanisms being put in place. And normally, the Regulations Review Committee would produce a recommendation against this. Now, of course, that may well have happened had this bill not had a truncated Select Committee process. Had the government not used its majority on the Select Committee to report it back 5 weeks early, perhaps the Regulations Review Committee would have had its chance to do its job, and they could have highlighted to the government the fact that this clause is a Henry VIII clause and it is not something that the Parliament should be passing. This clause, Clause 15.3c, particularly subpart 2a and b of it, allow the government, by order in council, to amend the Ombudsman's Act and the Income Tax Act without those amendments going to Parliament. That is absolutely outrageous. The Ombudsman's Act is actually quite an important part of our constitutional framework. It's not just a regular law, it's actually part of our constitutional framework, the Ombudsman's Act. And this government, it is a constitutional outrage. I've already said that. Listen up. And this Act gives the government, by order in council, the ability to change, to amend the Ombudsman's Act of 1975. The orders in council without reference to Parliament are not designed to amend primary legislation. They are not designed to amend primary legislation. Jerry Brownlee needs a lesson in how the New Zealand Constitution works. It's very concerning to learn that the Leader of the House, the guy responsible for overseeing how Parliament works, doesn't understand that the government should not change legislation without bringing those amendments to Parliament, debating them and having them voted upon. Jerry Brownlee seems to think to say, well, it's probably not surprising because this is the guy that brought a bill to Parliament that basically made him the Tsar of Christchurch, ability to change just about every law in the land without it having to come back to this Parliament. This clause is wrong. This clause is wrong, and it should not be allowed to stand. And in fact, I have a few amendments that I intend to table to this particular clause to allow us to examine that more fully. I want to turn now to supplementary order paper that's in my name, supplementary order paper number 64. It's been on the table for some time, so the members should have made themselves familiar with it. It's a very good supplementary order paper, Mr. Chair. It's a very good supplementary order paper because what it does is it allows, by way of background first of all, under the recommendation of the Select Committee, if a vote has been passed by one of these new mixed ownership model companies, whilst somebody holds more than 10% of the shares, under this legislation being proposed by the government, if the company could mount a case that they were unaware that someone held more than 10% of the shares, then that resolution would continue to take effect. What my amendment does is it does still allow that to happen, but for situations where the 10%, the person breaching the 10% cap, the vote was close, and it would have made a material difference to the outcome if that person had not held the 10%. This amendment basically says that the resolution passed by the company should not stand. So it's an important safeguard. It's a very important safeguard. I hope the government will vote in favour of it. It's in no way a frivolous amendment. In fact, it's quite an important amendment because it basically says that if someone knowingly goes out and buys more than 10% of the company, to exercise more than 10% of the voting rights, and then uses those voting rights, some resolution is passed. That would not have been passed had they not breached the 10% cap. That should not be allowed to stand. And this amendment guarantees that it would not be allowed to stand. So I hope the government will vote in favour of this amendment because it's a very, very sensible and practical amendment. Mr. Chair, so the two major issues that I've talked about are the Henry VIII clause under section 15(3)(c), and I hope the government will take that on board and support some of the amendments that I intend to put forward to that. And I hope that they will support my supplementary order paper number 64, which will amend clause 16 with regard to the 10% voting rule, because I think those are very, very important. To come back to the point of principle, and just one final thing, to talk a little bit more about 15(3)(c). The reason there is debate around whether or not the government should be able to declare these companies to be SOEs again if they decide not to sell them. And in doing so, and saying, OK, we're not going to sell them, we're going to make them SOEs again. They could do that without the flip-flop clause. It's the back-out clause, because they know they're on a hiding to nothing with this, because the public just don't like it. So this is the back-down clause. It's otherwise known as the Hekia Parata clause. That's right. It's designed to allow them to do that. Now, if they decide to keep 100% of them, they can make them SOEs again and make them subject, without reference to Parliament, to the Ombudsman's Act, the Official Information Act, and so on. So the question is, if by keeping 100% of them, the government think it's acceptable to make them subject to the Ombudsman's Act and the Official Information Act and so on, why wouldn't they do that if they're going to retain 51% of them? What's different between owning 51% of the company and owning 100% of the company? Why would it be that with 100% ownership? Why would it be with 100% ownership it shouldn't be? It should be under the OIA and the Ombudsman's Act, but under 51% ownership, it shouldn't be subject to those mechanisms. There's actually no justification for that. And in fact, these companies, if the Crown is going to own a 51% stake in them, they should be subject to the OIA and the Ombudsman's Act. They should be subject to parliamentary scrutiny, as fully owned Crown companies are and state-owned enterprises are, because it's ultimately the taxpayers' money that's involved in the shareholding here. It's taxpayers' money, and so they should be the subject of that. And unfortunately, under this 15(3)(c) clause that the government's put forward, the government could only make these companies that are becoming mixed ownership model companies subject to those pieces of legislation if they retained a 100% shareholding in them. Now, if we take, for example, Air New Zealand, the government doesn't own 100% shareholding, but it owns the vast majority of shares because it was sold off and it collapsed, and the government had to buy it back. That is not subject under this. It was the Labor government that did that, Mr Cosgrove, and it was a very sensible decision by the Labor government. Because of the failed privatisation of Air New Zealand, we were faced with a choice between having no national airline at all or the government buying it back, and the government buying it back. And so we basically decided, the Labour government, the then Labour government, decided that it should be purchased back because it was important that New Zealand had a national airline. The difference between that and this bill, of course, is that these things are bolted down. The hydro dams and the gas plants are bolted down. Very, very difficult situation if these companies collapse that the government's going to find itself in. So, Mr Chair, I strongly oppose this legislation. The Labour Party opposes this legislation. It's a bad bill.
Yeah. I rise to speak on this bill.